All right. So it's Tuesday, 3:30. Here I am live again, as I try to do every week. So uh, last night, Shorty emailed me a question, and so I thought I would address his question first. Uh, Shorty asked me, how long does it take to get your record completely sealed or expunged? Felony versus misdemeanor, or if there's any such thing. Some states like Florida allow certain things to fall off your record in 7 years. Does Texas do similar or not? So, Shorty, the short answer is no, Texas does not. A final conviction in Texas is a final conviction that stays on your record for life, unless you're able to obtain a pardon from the governor. Uh, so, yeah, I see you on there, Shorty. So, unfortunately, I do not have a way to get convictions off after a certain number of years. We have had plenty of clients charged with felony DWI, and their first two were well over 10 years preceding their new case. Um, Convictions in Texas stay a conviction. So, unfortunately, we don't have any law like Florida where you could change that. I had another comment from Gene on one of my posts, and it was a question about going to court for a weapons offense, and she wanted me to give some advice. So I'm not going to say the name, but because the name is unique, I was able to find that case. So first of all, my advice, just like it always is on here, is you need to get an attorney. And that's me or anyone you choose to represent, but I would never go to criminal court without representation. Now, that being said, this weapons charge, essentially the elements are that on a certain date in the county of Galveston, the state of Texas, did then and there intentionally and knowingly carry on or about his person a handgun that was in plain view in a motor vehicle that was then and there owned by the defendant and or under the defendant's control. So that's just the charge without knowing the specific facts. It sounds to me like the issue is going to be, was the weapon properly concealed or not? As most of you already know, in the state of Texas, you no longer have to have a license to carry a handgun in your car. However, it must be concealed. So since this says that it was in plain view, I suspect that is going to be the issue on how this case turns. Now, that being said, I don't know where the weapon was. How was it allegedly in plain view? Was it not? It says that the vehicle was then and there owned by the defendant, but I don't know that. That's just what the officer said. If that's not true, that could be a defense, which is something we're going to talk about in some of the other questions. So stay tuned. But if you want more specific information on your particular charge of carrying a weapon, you can call any of us here at the office, and we'll be happy to talk to you about it. So, Gene, I hope that was a little bit of answering your question. uh, the general questions we got this week, a lot of them deal with possession of a controlled substance, and possession of a controlled substance, possession of a handgun, possession of almost anything have a lot of similar nuances. So I'll try to tie that in while I talk about these questions. The first one is, what is possession of a controlled substance in Texas? And it means that a person has, well, first of all, possession is, you have to intentionally and knowingly possess something, and possession means that you have care, custody, and control of that something. So it means that you are knowingly or intentionally in possession of a substance that's defined as a controlled substance under Texas law. I got a question that's just too general, and it says, what are drug possession penalties in Texas? And it's anything from misdemeanor to, first degree felony because A, it depends on the substance, and then B, it depends on the amount. Real, not popular, but problem drugs right now on the streets are heroin and meth, which has been around for a while and it's problematic. But the amount that you have determines the degree of felony that you're charged with. Because when we're talking about like heroin and meth, there is no such thing as a misdemeanor possession of meth or a misdemeanor possession of heroin. You either start at a state jail felony, meaning you had less than a gram, and go up from there. But there is no, so without a question about specific weight, I can't tell you, what are the penalties in Texas. Next was, what are the penalty groups? And so to look through the Texas Health and Safety Code, there are way too many penalty groups for me to try to answer that in a live. I can give you some examples. Penalty group 1 is all the heavy stuff, heroin, cocaine, methamphetamine. Those are all penalty group 1 substances. But then you go down as far as Schedule 4 substances like tramadol. And depending upon which group you're in, also depends upon the seriousness by way of punishment and the felony that's attached to it. So I would need a more specific question than just that. What is second degree felony drug possession in Texas? And so that is the same thing. So using penalty group 1, which is again cocaine, meth, heroin, those types of things, you got less than a gram, which is a state jail felony, meaning minimum of 6 months, maximum of 2 years, and a fine not to exceed $10,000. Then you've got 1 to 4 grams, which is a third degree felony, 2 to 10 years in the penitentiary, and then 4 to 200 grams, which is a second degree felony, 2 to 20 years. And then of course you can go over that and you're at first degree felony. The problem then becomes if you go over 400, then you get a 15-year minimum. So a half a kilo is about 500 grams. So if you're close to a half a key, you're looking at a minimum of 15 years to life in TDC. Now, across all of these also exists the possibility of probation. But for the degree of felony, it's going to depend on the weight. Here's a good question. What is constructive possession in Texas? So there's lots of ways to think about this. Perhaps one of the easiest ways is when you leave your house, you still own all the things in your house, right? You're not there. It's not with you right then, but it's still yours. That's an easy way to think of constructive possession. Other ways could be, if it's your vehicle, you could be constructively in possession of whatever's in the trunk at the time, right? Now, this is where things get tricky, and I've told more than one jury, when we're dealing with constructive possession in a vehicle, ownership of the vehicle becomes very important. Otherwise, if you walk out one morning and find out that you've got a flat tire and your neighbor says, here, man, take my car so you're not late to work and lose your job, and then, you get pulled over and it turns out your neighbor had a kilo in the trunk, you're not in possession. You didn't know. It's not your vehicle. You didn't do an inventory of the vehicle and the contents of the truck before you took it. So it's not just so simple as to say you're in constructive possession. There has to be evidence by the state of some further knowledge before you could get a conviction, in my opinion. We already talked about expunction basically with Shorty. What is the Texas 3 strikes law? So we don't really call it a 3 strikes law. I mean, I know where that comes from. What we do have is on your third felony conviction, you can be charged as what we call a habitual. And if you are charged as a habitual, that means your punishment range is 25 to life, no matter, where you fell in the spectrum. There are some nuances, like the two prior felonies have to be apart from each other. In other words, if you catch two felonies, work out a plea deal and work them both out and plead them at the same time, that doesn't count as two for habitual purposes. That only counts as one. So you would have to have caught a felony, been convicted, some time passed, then you caught a new felony, were convicted. Now you've been charged with a third felony, and you can be charged as a habitual, meaning that your punishment range will be 25 to life. But in the court system, we don't call it in Texas a three strikes law. We call it a habitual. How long does a felony stay on your record in Texas? That was kind of Shorty's question, which I've already gone over. And here's one that's kind of strange. What are Texas bail conditions? And that's almost impossible to answer. It can be almost anything. The courts have wide latitude to set whatever bail conditions they deem appropriate in a case. Practicing as long as I have, you can, if any of you remember the days of Judge Poe over in Harris County, he would make people carry a sign, I'm a thief or whatever. And sometimes I think they were bail conditions, and sometimes they were probably conditions of probation. But there's a lot of wide latitude given to courts as to what they can set for bail conditions. Here locally in Galveston, we have some courts, for instance, that do drug testing, others that do not. It kind of depends on the individual judge, I suppose. But, any condition you can think of. We've got house arrest. You've got GPS leg monitoring. You've got nothing. You've got just pay your money and show up to court. You've got attend counseling. I mean, one of the most popular ones we see here is no contact orders, like with a victim. I froze here. If you have a victim case, the court will often impose a condition that you have no contact with the alleged victim. Can't go near them or their place of work, things like that. So there's not just one single list I can give you for what are Texas bail conditions. It's almost anything a judge can think of. And that pretty much runs through everything I had for today. It's kind of quick, coming up on 15 minutes. I don't see any other questions. But if y'all think of any, just email me or comment, and I'll be back next Tuesday. Thanks, guys. Y'all have a good week.